like one case remaining, and that's State versus Shinn. The state has waived argument in this case, so it would just be you, but I want to make sure, since we have 5 minutes before the actual time that we're supposed to start. Do you have anybody coming that we need to? No. All right, then if you're ready to proceed, we're ready to listen. You'll have your full 15 minutes on.
Okay, great, thank you.
Don't need to rebut yourself today.
I don't think so.
Okay, thank you.
Okay, thank you, Your Honors. May it please the court, Attorney Angie Killey on behalf of Charles Shinn, the appellant in this matter. This court is aware this is an appeal of the sentence in this matter. Mr. Shinn pled guilty to 1 count of felonious assault with an accompanying firearm specification and was sentenced to a total of 10 years in the Ohio Department of Corrections by Judge Forable Jones. Mr. Shinn asserts that that is an abuse of discretion by the court, although it does fall into the sentencing guidelines that it was not appropriate in this instance given the other factors that the court is supposed to weigh in these circumstances. We certainly do acknowledge that the firearm specification is a mandatory consecutive prison sentence, so Mr. Shinn was aware that he would be going to prison. Our argument is that the 7-year sentence should have been a minimum sentence or on the lower end, given the fact that Mr. Shinn has almost no criminal history. I know that the courts are very good at putting some form language in their orders every time that they sentence somebody in order to appease appellate courts in their review of it. But it's our position that the abuse of discretion comes in because she didn't actually weigh those factors. When you look at the factors as to whether or not the offense is more serious than what normally constitutes the offense, we would agree that the harm in this case is very serious. Mr. Shinn didn't deny that at the sentencing time as the victim was paralyzed from the waist down. However, it's our position that everything else weighs in favor of Mr. Shinn having a more nominal sentence. It's less serious than what normally constitutes the offense because the victim provoked this by assaulting him physically and unprovoked in a bar. On that same instance, he was still under fear at the time that he walked out of his apartment, and that's why he brought a weapon with him. So this was induced by the victim and makes it less serious. In regards to the recidivism, not only is it the factors in regards to it being more likely than not, none of these apply to Mr. Shinn under the circumstances. And for less likely, they all apply. He has just a nominal misdemeanor history. He always had a job from the time that he was out of high school. Even while he was out on bond on this case for 18 months, he committed no offenses and he obtained and maintained full-time employment during that entire time while he was complying with the court. He did show some genuine remorse in his speech to the court. He also obviously has substantial support in the community from his family and friends. And I think most importantly, what the court failed to look at is that these are circumstances that are not likely to reoccur. I think if there is obviously a slight dispute of facts, which was never really resolved as a result of it being a plea as opposed to any type of a trial. But from Mr. Shinn's perspective, where this began as 2 gentlemen who had a very friendly relationship that went incredibly far south and quite frankly must have had some alcohol involved since they were after hours at a bar. I don't think it's something that's likely to reoccur or that he would reoffend. And I think that by not looking at these, the court did abuse its discretion, that he should have had opportunity for a lighter sentence and perhaps opportunity for early release in order for him to be able to do that. The sentence that he has, he doesn't have any of those. And unless the court has questions at that point, I would rest on the brief as it's a pretty straightforward area of law. So.
Looks like we don't have any questions, so we will take the matter under advisement and obviously we'll issue a written opinion that will be sent to both sides and we'll release it online as well. Thank you for your argument and presentation today.